went around real quick and just said who we were and who we were participating
Of
with,
course.
so everybody knows who we're on the phone.
That makes really good sense, Mark. Thank you.
Yeah, yeah.
You have the floor.
Mark, I think everybody on this call knows me. Community member, former state representative for House District 60, which is all of Harney County. I would hand it over to Dark.
Good afternoon, everybody. I'm Dark Boschman. I'm a hydrogeologist in the groundwater section based here in Salem.
And just keep handing it over as you go, and when we miss people, we will figure them out at the end.
Let's go to Ben.
Howdy, I'm Ben Scandella. I'm the senior groundwater data developer at the department, and I've been running the model in support of the RAC process and now the petition. I'll pass it over to Harmony.
Hi, everyone. Oh, yep. You can hear me, right? Okay. I'm Harmony Burright. I'm here because I'm helping draft the voluntary agreements in the community. So there's just a lot of moving parts. I'm hoping a couple of the folks who are really kind of on point for the groundwater users in those areas will be able to join, but I'm here in the event that they're not able to just kind of help figure out how to integrate that with these conversations. Thanks for having me.
And passing it to
Doug.
Okay. Doug Woodcock, Deputy Director for Water Resources Department, located in Salem. And I will pass it to Patty.
Hello, everybody. Patty Darrow, Harney County Commissioner, so a member of the local governing body in Harney County Court, which was a co-convener of the community-based water planning, place-based planning. Thank you. Passing it to Tim.
Hi, Tim Seymour. I'm the Assistant Manager for Groundwater, and I'm based out of Pendleton, Oregon. And I will hand it over to Jason.
Good afternoon, everyone. Jason Spreet. I'm the East Region Manager for Water Resources based out of Baker City. And I will hand it over to Sabrina.
Sabrina Mackey, resident irrigator in Harney County. Oh, sorry. I don't know who to hand it over to. I'm driving.
Dominic.
Thanks.
Good afternoon, everybody. Dominic Carollo. I'm county counsel for Harney County, and I was asked by the Harney County Court and Representative Owens to join the call today.
Tracy, are you available?
Good afternoon, everybody. Tracy Kennedy, Burns Paiute Tribal Chair.
Nick? Nick or Andy, doesn't matter.
Andy's here. Andy Rutt, irrigator, farmer, business owner, Burns, Oregon.
Chandra?
Hi, good afternoon, everyone. Chandra Ferrari, Natural Resources Policy Advisor with Governor Kotek's office. Apologies, I'm also needing to be on my phone for a bit this afternoon. And I also can't see who to send it to. Sorry.
Stacy.
Excellent. Thanks.
Good afternoon, Stacy Clark, Chief of Staff to Rep. Owens. I don't think Elizabeth is gone.
Elizabeth Howard. I'm a natural resource and water law attorney at Schwabe. I think everyone knows I've been working with Representative Owens and Andy throughout this process. So appreciate the opportunity to be here.
And who have we missed? Nick, are you available yet? Nick Green.
Yes, thank you, Rep. Owens. This is Nick Green with Catalyst Public Policy Advisors. I'm working with the City of Burns as a policy analyst.
Thanks, Nick. Who might we have missed?
Kelly.
Kelly, of course. Sorry, Kelly.
No worries. Kelly Mines, OWRD Rule Coordinator and Policy Analyst.
And Ivan.
Ivan Gall, Director for Water Resources, unfortunately on the road and on my phone, but welcome everybody.
Thanks, Ivan. Well, I think that's all of us, Doug. Just to start out, I mean, I'm sure you all have read the petition and gone through, and many of the department staff that is on this call sat through the Groundwater Study Advisory Committee with us, participated in place-based planning, and have been active leaders in the Rules Advisory Committee. And if you looked at the parts of the petition and the rules, I don't think there's anything surprising that came forth. We had a lot of conversations in the RAC, a lot of community members that were involved in that RAC and others talked about unique groundwater measurements, unique groundwater places, and maybe Silver Creek, Donner Blitzen, and Sylvie's. We talked about putting triggers in. We talked about if these areas are already reasonably stable, what can we be doing? What should we be doing? We tried to work through with the department to figure out how we could match staying reasonably stable in those areas that aren't reasonably stable, what regulatory actions would have to occur, and how we can continue to use this resource into the future. And I believe that's what was written in the petition and articulated in the RAC meetings is what has come forward. And we modeled it loosely off of Alternative B that was presented in the last RAC of 24. That a lot of us thought at that time we were real close. But conversations we didn't have in the RAC, we never really talked about the cities. We never really talked about allocating only 110% of the 6-year usage, how that would affect economic development, how that would affect our communities. We did have participation from the tribe, but we never really addressed tribal rights. What was the right thing to do with it? How should we work through those? So those are, petitioners that we brought into the conversation. Jess Winnick was there at the end for the refuge. And we've talked a lot with Jess, he's unfortunately can't make it today. And what do we know exactly about the impacts to Sodhouse Springs, Warm Springs, 00 Spring Complex? Are we being maybe a little bit too broad a brush on trying to protect those where we don't have enough information to understand that maybe we tapped into the same vein of water that was feeding Sodhouse Springs, but yet now maybe we're causing a regulatory action in an area that in our anticipation doesn't need it? So I don't think there's any surprises here, Doug or Ivan and team. I think it really represents some of the outstanding questions that the local community RAC members had and that we found out that our city's tribe and refuge has since the first comment period was opened up, Doug. So I don't know if we want to have any short conversation on that before we talk.
Well, I don't know. What does the group want to talk about today?
We want to spend a lot of time on the modeling scenarios that you did. But we wanted to start with the intent and objective of the petition and see if you guys had any direct questions for us, or if you had any direct questions on, is there anything in these draft rules that were a no-go when you read them? Is there anything in these rules that you guys felt collectively would not reach, perpetual use of the resource? I guess we're just trying to have that, what we had hoped maybe that conversation prior to some of the modeling, or just have a conversation, Doug, before we get into the nuts and bolts. So.
Okay. Do we want to go ahead and step through the petition? Kind of directing this back at you, Mark. Go ahead and step through the petition, and that will then lead us into questions about how the 512 rules and the petition compare in terms of what you've seen the models for the 512 rules. Now we have the petition and what it is proposing to do. Will that lead us into that conversation in a straight way, or do you want to discuss the model results first? And I think I shared with you as we were communicating over the last couple of days, and I haven't checked in with my team today to know, but we were not finished with this analysis yet. And so we have to caveat some of this.
I think, can I jump in really quick?
Of course, anybody on this call, please, jump in, raise your hand or whatever. We hope this to be a conversation and not just Doug and I going back and forth. Not that, no offense, Doug, but yeah.
I mean, I think, Doug, it would be super helpful to understand the comparison, but I also, I think there's kind of a spectrum here of where we might land. And I think I'm super curious about whether the department could get to the point where it felt like it supported some or all of the proposals in the rulemaking, in the petition. Sorry, my camera like has me exactly opposite of how I actually am in my office, so it keeps on throwing me off. But I would just be super curious, like, because I think our hope here with this petition was, could we find some common ground with the department? Can we get to a point where we still are protecting the resource, but also providing maybe more protection for social and economic welfare? And then also we were trying to get at addressing some of the environmental components that maybe we thought we could boost that up a little bit. So I just, and the department, even with all of the different models that we've run, you guys have run, there have been sort of a wide spectrum of how we might get to protecting the resource. So with all of that said, I think there could be a different places that we might land and still achieve that goal. So I think in the spirit of trying to work collaboratively together, I would just be really curious whether there were areas in the rulemaking where you all thought, well, boy, if we could tweak that, we might find some common ground and the department could get behind that. Or were there areas in the petition where you guys would say, hard no, we can't get there because of X, and then maybe we could talk around whether there's some roads forward on that. But I think that was what I was really hoping we would be able to accomplish today, in addition to understanding your guys' analysis of the petition from a modeling perspective, understanding it's been a little bit of a whirlwind and you're still in process. So if you're ready to have that conversation, maybe you aren't ready to have that conversation yet, but that would sure be helpful for us as we're trying to think about how do we get there together.
Chris, I see you have your hand up, but I want to respond to Elizabeth here real quick. I don't know that I'm in a position yet to just say, oh, we like this, this is a no. But I was thinking that if we went through the petition, that will raise the opportunity to have some conversation back and forth on what it is that you're trying to do. And that will help us as we have more opportunity to analyze the petition. Just haven't had a lot of time since we've come back from the commission meeting when we first saw this.
Okay.
That's fair. Yeah. Could we go to Chris? Chris is the general manager of the Burns Paiute Tribe. And Chris, thank you for joining us.
Yeah, thank you guys. Appreciate meeting everybody and everybody taking time out of the busy days to meet, to talk about something that's so important. So good to see you there, Douglas. But I think, the Burns Paiute Tribe, along with the Basin partners here, we have submitted consistent language and policy recommendations to both the OWRD and rulemaking, where we had a meeting, Douglas, twice. And you guys said you would consider working with us in consultation. And then the very next week, you shut us down. We didn't want to consult no more, didn't want to do anything. And then a week after that, then you open it all back up again. And now you want to have consultation again, that we have set up in the near future. But again, right now we've submitted consistent language, policy recommendations in both official OWRD rulemaking record and the alternative rulemaking proposal. So these are not competing proposals. They are parallel, complementary processes aimed at producing a groundwater framework that reflects scientific reality, legal equity, and basin-wide consensus. And that's important that, the people that actually live here are on a consensus. That's how to accomplish something. This opening does three important things. It anchors the legitimacy of the alternative rulemaking. It shows the tribes acting in good faith, not obstructing, but contributing constructively. And it frames OWRD attempt to ignore the alternative as a procedural in a legal problem. So given that our language is fully aligned in both official rulemaking and the alternative proposal, and that the intent is clearly to build the complementary, science-based, and equitable groundwater framework, how does OWRD intend to formally recognize, integrate, and advance the alternative rulemaking process so that it remains a co-equal pathway and it's not going to be silenced by a flagpole draft? I think that's real important to the tribe. This can't just be check boxes. You got to take it serious. Thank you.
Thank you, Chris.
So thank you, Chris. And well, Doug, I think you're right. Maybe we should work through the petition or the draft rules, whatever you'd like to work through, or both of them. I don't know which document would be most advantageous to work through. We got Chandra, hands up. Chandra?
Yeah, thank you, Mark. So just a quick question. We're in an interesting, I think, procedural space at this point with the petition, of course, and the proposed rule. And I've heard you, I believe that was Chris just a minute ago, saying that, hoping that this is going to be more than a perfunctory review. And of course, the thing about proposed rules is that they do follow a pretty significant process that involved multiple people in Iraq. And Mark, you alluded to that earlier. And I'm trying to understand, I know that you have folks that have supported this petition. How did it intersect with the folks that were sitting on the rack for the rulemaking, or for other folks who have been involved in these processes for the last going on maybe a decade, or have been involved in place-based plans and that kind of thing?
Yeah, great question, Chandra. And before I start there, so Doug, I could see, thinking through your question, maybe I won't go to the question, but yes, we had discussion groups, we had a lot of dialogue that was outside the rack, and we thought we were threading that needle. But unfortunately, a lot of the community was not paying attention, and we surprised a lot of the community. But Chandra, on your exact question is, how does this intersect with those that participated in the rack or participated in place-based planning or the Groundwater Study Advisory Committee? There was a lot of overlap, I think, in all three of those entities. I think what I said earlier will resonate with the majority of the RAC members. What you see came forward in this rules or this petition are a lot of the dialogue and conversation that we had. I am crafting another letter that I will send out to the whole RAC. I asked Kelly for the list of official RAC members just yesterday. Kelly, thank you for getting that to me. And I'll ask them to weigh in. I'll ask them to weigh in if they support the petition. I'll ask them to weigh in if they felt that it was more aligned with the conversations that had occurred. And we'll see where we're at. I mean, 29, I think, of those 32 were local community members. Unfortunately, 4 or 5 of them never showed up to begin with. A couple of them only showed up 1 or 2 times. Some of them left, after several meetings because of frustration or personal reasons. So when we compare the numbers of signatures of RAC members that would support the petition compared to the full 32, I'm not sure we're going to get a clear example. But Chandra, I do believe that the majority of the RAC members will support this petition. Place-based planning, I was involved with the groundwater portion of place-based planning a lot. I heard a lot of this. I kind of stepped aside during the surface water part, so I'm not going to weigh in on the place-based planning members. Before I go to Harmony, you want to quiz me a little bit more, Chandra, or is that what you were looking for?
Oh, that'll be good for now, but I appreciate the response. Thanks, Mark.
Okay, yeah, Harmony.
Yeah, so I'll kind of put first the hat on of so I was working with High Desert Partnership just on the public comment process, so helping people understand the rules, talking them through how to comment, developing materials so that people could kind of wrap their head around it and provide comment. And through that, spoke with over 120 people in the basin, some of whom, just at the, public meeting, the second one in August, that was the first time they'd heard of the rules. And that's not necessarily, the department did a lot of outreach, but then from the perspective of the person whose life is going to be impacted and who is hearing about something for the very first time with 2 days to comment, there are these two simultaneous realities, right? The department doing all this outreach and then the people who are hearing about it fairly last minute and who are likely to be impacted by it and all of the feelings associated with that. And I will say, in talking with and trying to get the RAC members themselves to comment on the rules, I will say that there are a number of RAC members who really, and I did message both Kelly and Jason about this, they were just, they really did not feel that their voice mattered. And it was really, it took a lot of work to get them to contribute to the public comment process during the public comment period, because they just really firmly believed that anything that they had to say didn't matter. And that is what I heard. And that is what, I encourage them, if that's what they felt, to speak that truth. And I do believe some of them put it in public comment. In terms of why there is that disconnect, I think you would have to speak with them personally to understand why is it they feel that their voice didn't matter. And a lot of folks then, I'll put my other hat on of the voluntary agreements. I really got, I was doing outreach on that and trying to get people organized, and we didn't have our first meetings until May. And by that time, things were pretty well baked in the rulemaking process. And also, these folks working on voluntary agreements, many of them, this was the first time that they were hearing about the fact that there were regulations proposed for their part of the basin. So some of them had plugged in at the beginning of the rulemaking when there was a proposal for targeted regulatory action in Weaver Springs and Northeast Crane. And then the kind of approach of, holding people steady at 2018 pumpage levels with a trigger for curtailment. And people were pretty locked in that was the department's framework. And so then when I was talking to people in May, they were very, very surprised that now the department was proposing regulation. And they were very surprised at the level of regulation being proposed, because most of those folks in a couple of the spaces where we're trying to work on voluntary agreements believe very strongly that their groundwater levels are stable, is the word that they use. But what does that mean when we use that word? So that's some additional perspective, but each of the 120 people I talked to had a very different take on everything. There was, it was all over the board.
Thanks, Harmony. I'm curious, I'm sorry, just one more quick question. Do you feel like folks in general, assuming the rule does get adopted, are aware of the process points from rule adoption to when regulatory action would happen, like the process steps that happen in between those points, which could be relatively lengthy?
Well, it depends on who you ask. So the other thing that's just really important is there's like who the person is, what their kind of hat they wear, their affiliation, and then where they are at in the basin. And so, for instance, the domestic well folks close to Weaver Springs are very concerned with the amount of time. They are very aware of the process steps. They're very aware that it's going to take a while, and they're very concerned about it. And then you have folks in another part of the basin that didn't think that there was going to be any regulation at all. And so they were not even trying to understand the process steps because they just didn't think regulation was coming until May. And now there's a lot of scrambling happening. A lot of people are scrambling to try to figure out what this means for them because they did not anticipate that they would be affected by it. And they did not, that kind of realization did not dawn on them until, for a lot of people that I've talked to, until May or June of this year. So there's a lot of, but we have now, like, I mean, the benefit of the organization around voluntary agreements is like, there's a way now to like talk to all these people in a really targeted way that I just don't think we didn't have that set up earlier. And so it was hard and there wasn't necessarily someone doing that work. So we just didn't have that targeted outreach.
Gotcha. Thank you. Okay, I'll be quiet.
Chris.
Yeah, I just thank you for letting me speak. I had one more thing I really wanted to bring up. Douglas, I had asked a question previously, just moments ago, and you denied to answer the very last thing, which is the question I had asked you, which was, how does OWRD intend to formally recognize, integrate, and advance the alternative rulemaking process so that it remains a co-equal pathway and not sidelined by a flagpole draft, was what I asked. And there was no response to that. So this is the same exact attitude that we got about these rules. We've been asking you guys and being very kind and showing you the state rights that were given in 1940, 1947, 1991. That's a historic problem. That's not the tribe's problem. It's not the tribe's fault that the state thought that they could issue a tribe rights. Because in 1940, 1947, 1991, you have to understand, Burns Paiute tribe is the only historic tribe in the state of Oregon. So they didn't sign a treaty. So they don't sign a treaty until 1972, they finally get federally recognized. So 1940, 1947, 1991, the state never could even give us those. You couldn't give us any rights the federal government had already given us, for one. So all those rights do is they acknowledge rights that the tribe already always had. That's what those rights do, in my eyes. They just acknowledge rights that the tribe always had, and the state put it into legislation for us. So thank you for that. But we want this now new language that we had given you put into, the rulemaking. We want this alternative rule to be accepted. It's, it's the community put this together. This was a community-led effort. Mark Owens put in a lot of time to make this happen, and I think it should be respected, and people should be respected with how you're putting things out there. For example, why would you tell the tribe that for all this time through this consultation that you're protecting their water rights with Rule 512 when you were taking away their water rights? That would have protected their water rights. The tribe would have gave up sovereignty if they would allow you to curtail their water rights. And then you would submit every tribe to the same standard that in the state of Oregon, and maybe even federally across the board, that would become a new standard. So we're not going to sit here and allow that. We're gonna push back, and I've told you this. That's why we're trying to work together. Ultimately, we need these exemptions, and in the city obviously needs exemptions. You cannot put you can't have a water right rule on the city of Burns and Hines. That would make no sense. What are you gonna do? Tell McDonald's, hey, you guys better quit making shakes over there. You use too much water today. I mean, that's crazy. And then the co-stewardship, you know, that's a great model. You know, co-stewardship has proven to work everywhere across the globe. It's a proven model. Co-stewardship works. It's these single models that don't work, always conflict. So I think I would appreciate some answers. I appreciate to know what you guys think about this stuff, because how are we as people who are commenting or people who are trying to, you know, we think the rules need to be changed. How are we supposed to work with you to make that stuff happen if you guys just turtle up every time we come to the table? You know, it's not really fair to people who are trying to get answers and try to draw solutions. And again, you know, I say this with 100% respect. No disrespect at all, but I just want to really be clear on, you know, where we stand and how we feel about this stuff. Thank you.
Thank you, Chris. And Dominic, I see you have your hand up, but I want to respond to Chris. Chris, I'm sorry, I didn't realize you had a question there at the end of your previous comment. So I will tell you that we are going to follow the process that we have in rule and statute. We are bound to do that. So that is what we are going to do. And know that involving this process that we have before us that we're talking about today with an alternate petition for rulemaking, you may be aware we work for a commission. The commission decides what we are going to do with this petition. So we're going to analyze it and we're going to work with our commission, and the commission will ultimately decide the fate of this petition. And as I understand it, we have a meeting with you, consultation Monday morning. Is that correct?
Yes, sir, that is correct.
Okay. I look forward to it. Dominic. Oops, you're muted.
Sorry. Thank you, Doug. I just had a couple things to add that I thought may be pertinent to the discussion around the rack. I mean, so first of all, I come at this at maybe a slightly different role in some of the other contexts I've been involved with OWD rulemakings. I represent a lot of private irrigators and private water users throughout the state of Oregon. And I've been involved with, I think the department knows, several or at least a few different rulemakings in the past where there were racks, different stakeholders, different interests that are represented on the rack. And I, you know, and I've followed or participated in those processes to some degree. In this situation, the county, while it has a very significant interest in these rules, isn't necessarily in the same position as a lot of the water users are. But I will say that, like, and I guess also in that vein, I have not participated in these racks really closely. I was not a rack member. The county is represented. I did attend some meetings, and I'm not here to offer any criticism of this particular rack. My comment really is more about the racks in general, which is that, you know, you have a lot of different stakeholders that express a lot of different viewpoints. And in my experience, you know, at the end of the day, and maybe this gets to your point, Doug, there's a policy call that's made by the commission. And I think there's some policy calls made by the department leading up to commission decisions about what weight to give to those different perspectives. You know, you have a lot of different types of stakeholders. And, you know, I wasn't involved in putting this petition together. I'm the county counsel for Harney County, and Harney County's supportive of this petition. I'm familiar with it now, but I would just say that, like, you know, to people talking about maybe people felt like they were ignored or different things. I mean, ultimately, I think what this petition is trying to get the point across a little bit is that, you know, the local community really wants a little bit different, better solution that's a little bit more targeted, that's a little more site specific, and maybe is a little more nuanced than what they're perceiving is being proposed. And, you know, I would just say that it's a pretty reasonable position when they're the local community that's going to be most affected, not different organizations in Portland or other areas of the state. I mean, these people are going to have to live with this for a long time, and their businesses, their livelihood, you know, whether their kids can live in that community going forward and the jobs, it all depends on this.
Okay, thank you.
So Chandra, you're the one that started this with a question about the RAC participation and maybe the RAC's feeling of this petition. So up until RAC 7, this department started in the first couple of slides that we are here to collaborate. We're here to work together. And members of the RAC started dropping out shortly thereafter. Because the department changed the first couple opening slides. And we were no longer there to collaborate. They were there to inform, consent, and maybe something else. And that's where things started to go maybe awry. We felt that we were being there to check a box. We did get some good things accomplished, with extending the reductions for a 30-year period of time to try to balance economics, adaptive management. I'm not saying not everything was taken, but some of the key issues of whether they should be a critical groundwater designation, are they reasonably stable, I think got thrown to the side. So I didn't want to take too much time, but I'll follow up with you on that. So.
Yeah, I appreciate that. I mean, yeah, we should definitely follow up. I think we've been trying to get clear as an administration or state agencies in those processes that, they are seeking consensus, and at the end of the day, when, a determination needs to move forward, right? An action needs to move forward that's based on the best available science, that's consistent with law, and that hopefully brings as many folks on board as possible and is certainly reflective of communities' interests and needs. But, getting 100% consensus is rarely possible, right? And so I think along the way, we've been trying to make sure that expectation is clear. Like, we're not going to sit around a table for 10 years until every last person says yes. That's just not practical. So what does it mean to have people around a table trying to get to a consensus-based solution that might not be 100% consensus? And so I do recognize that can be jarring and confusing, and from a state agency perspective or from an administrative perspective, we're just trying to be as transparent as possible in how we're characterizing what we're trying to do in RACs. And we can talk a little bit more about whether or not that hit the mark or didn't. But I think there were some of those conversations were evolving during the course of when these RACs were going on, given that there's a pretty lengthy public process associated with this one. So, but yes, let's chat about that later.
Thanks, Chandra. And I don't want to undervalue the improvements that we made. Collectively with the department, we made some good changes. We did. The majority of our community wasn't involved with those. So a lot of them are still playing catch up.
Gotcha.
All right. Any other questions or comments before Commissioner Doro?
Commissioner.
Yes. Can you hear me? I have technical problems sometimes.
Yes.
So what I hear, what I've heard very recently, and what we discussed at the county court level, is that a number of things. And one is that the proposed petition rule amendments, while not perfect, they show compromise among the community that is signing onto it, because they're very concerned and they want regulation to the right extent. But the petition now reflects numerous actions and recommendations from the place-based planning integrated water resources plan that isn't reflected right now in the Division 512 rules proposed by OWRD. The comprehensive and coordinated approach over many years really hasn't made it into it, and the petition will help do that. The basin entities and partners worked together for years to develop the goals of reasonably stable groundwater conditions in the Harney Basin and attempt to protect the public health, safety, and welfare of the community. It's a give and take, but that's a very important thing that now the levels of regulation and the relatively late addition of, from our perspective, of aggressive curtailment regulation in areas of the basin that were and are perceived to be reasonably stable, but are now facing rules of levels of curtailment that are frankly shocking to the people here and have created alarm and the belief that the rules are statutorily failing to protect the public health, safety, and welfare of the community, which is an entire Oregon County. And so that is a real concern that we believe the petition amendments help to address, because we have regulation is needed, but if you get too aggressive, you're going to devastate our county. And that is a statutory requirement. And I know that there's no perfect economic models, unfortunately, that then people can feel comfortable with. But I just wanted to make that statement. Thank you.
Thanks, Commissioner.
Thank
I
you.
noticed that I noticed Bob Long joined. Bob, we want to introduce yourself and make any comments before maybe we go through the rules of the petition.
Sure, Mark. Thank you. I'm Bob Long. I'm representing the city of Burns and some other ranch clients in the basin. I'm a hydrogeologist, registered geologist, and certified water rights examiner over the past 29 years, 30 years, and have been following the development of the basin rules, and am here to listen and participate on technical matters or as requested.
Thanks, Bob. And also, Rick, I think you came in afterwards too, if you wouldn't mind introducing yourself.
Absolutely. I'm Rick Eichstad. I'm outside legal counsel for the Burns Paiute tribe, and I've assisted Chris and the tribal council in this matter.
Thank you, Rick. Well, any other comments or questions before we go to working specifically through the rules or the petition?
Maybe to tee that up, Mark. Yeah, just, I mean, I appreciate what Chandra said earlier about best available science and maybe not always being able to reach consensus, but working towards that. And I think as we put this petition together, those things were top of mind for us as well. We tried to draft a petition that, rules that really reflected community input. Oh, somebody's got a lot of background noise there. Maybe you can go on mute if you're not speaking. But also, the department, there's a spectrum of where the department might land in order to achieve reasonably stable groundwater levels. And I think we thought, and to protect the resource. And so as we were putting this together, we clearly had in mind that the department has to reach that goal, right? We have to reach stable groundwater. We have to have protection of the resource, but we also need to protect and think about the community and the effects on the community. And I do think that there's a way to find that balance, and that it can be based on grounded in science, and it can be also based on principles that really do think about how do we balance the science and also and be able to give the department a defensible position in that regard, but also really think about the community and the community's input. And I mean, I've been doing water for a very long time, and this is maybe the first time where I've seen a community spend this much time and energy just kind of coming together and compromising between themselves. And we talk a lot about wanting communities to really have a voice and wanting to really support communities and trying to come up with collaborative proposals for how to manage a resource along with the agency. And I really hope that this is a situation where we can lean into that and really recognize all of the amount of work that's gone in here. And so I just wanted to kind of share that. And then also just the spirit behind the petition is really not to throw out the science. In fact, to the opposite, right? We talk a lot about the science and trying to achieve these resource protections. It's just a different way to get there. And it's a way that really recognizes the community's interest while we're getting there. So that I think is really the spirit behind the petition. And Mark, please jump in if I got anything wrong there, if you want to modify that.
Not at all, Elizabeth. I think that was very, very well said.
So I'll go ahead if you want me to. I can kind of help walk through the petition, or at least I think it'd be helpful if folks have the rules in front of them, and I can just try to kind of explain how we put this together. And it was a labor. Doug, I don't envy you and your staff trying to put together rules. It's no easy task. But you know, we just tried to have the summary at the beginning of the rules. It sort of set, if you will, the regulatory mechanism that we're looking at here. You know, limiting, particularly in Weaver Springs and Northeast Crane, the amount of withdrawals, the timing for doing that, and then just making sure that we're clear that when the department gets to the allocation process after the contested case, how that allocation would occur. We really focused in on Weaver Springs and Northeast Crane because we know there are areas those are the areas that need to be addressed. They clearly have declines and we clearly need to be taking action. And our goal with Weaver Springs was to get that implemented as fast as possible. And then with Northeast Crane, again, our goal was to get that accomplished faster, if you will, than what was proposed in Alternative B. And again, we focused on those areas because those are the areas with the most significant declines. And then as Harmony sort of shared earlier, in the other three areas, Silver Creek, Blitzen, and Sylvie's, we wanted to make sure that we really, I mean, this is super exciting that we have this voluntary agreement process going on. Let's do it. I'm super excited that we might actually get some of those going. That's something that's been a statute for a very long time. I think it's really exciting that we're having conversations around that and really supporting those efforts. So the goal for those three areas, recognizing that we don't have the declines in those areas, is to start with volunteer actions in comparison to the Alternative B that was proposed. We're actually proposing to do voluntary actions with a higher percentage of reduction in those three areas than what was in the Alternative B. We put a time frame for those to be implemented, and if that time frame is not successful in seeing those reductions, or we have a 25-foot decline, which is actually smaller than the excessive decline number, then we have a regulatory backstop in place. And that was intentional because we want to make sure that if we're wrong, if the voluntary agreements aren't successful in maintaining stability in those areas, then we want the department to have the ability to step in if needed to address that. Again, I think just to speak to compromise, like in those three areas, we have a number of folks who actually didn't want to have any sort of limitations, but in support of this alternative and having this in place of, if you will, the department's proposal, they're willing to get on board with that approach. And Doug, did I see? I think I maybe saw that you had a comment or question.
Yeah, I had my hand up. Thank you, Elizabeth.
Yeah.
You've made mention a couple of times to option B. I would ask one of my staff that was familiar with the early modeling runs, could somebody explain what option B did and what was the result of option B?
Ben, do you have the info for that right in front of you? Otherwise, I can speak to it.
Yeah, I can share a slide from Rack 10 describing what those changes were, though I don't know if it has the actual amounts of reductions handy.
I know him, Ben. It was 54% in Weaver Springs, 30% in Northeast Crane, 9% in Silver Creek.
Yeah.
And basin-wide, 22%, I think.
Yes.
That's right.
And I'm probably calling it option, and it should be scenario B. So sorry, that might have been a little
Okay,
confusing.
that's fine.
And then
under those, Go
reductions
ahead.
were also phased in over a 30-year timeline, correct?
Yeah. Even by decadal over 30 years.
I'm
Yeah,
sorry,
I
can you
think-
guys, I'm sorry, can someone repeat that again, the percentages?
So it was a 22% basin-wide reduction is what it came down to. It was targeted in, I believe it was 3 of the 6 sub areas that we tested. Weaver Springs having the most, Northeast Crane having the next most, and then Silver Creek having the least.
Thank you.
And
then
Harmony,
Chandra-
Chandra, that, oh, go ahead, Mark.
I just say Chandra Weaver Springs was 54%. Northeast Crane was 30%. Silver Creek was 9%.
Thank you.
And that's in the petition. So I'll be curious to see what slide that Ben's going to show, because we have a couple slides too.
Thank you.
I think
So
we covered all the content I was going to show. So if you have something, go for it.
No, I mean, Ben didn't not say in that PowerPoint presentation to the RAC and to the commission, because the commission also received a synopsis of those alternatives, that it would, how was it exactly phrased, that there would be no longer depletion of the groundwater reservoir within 30 years.
Yeah, so I think that's a key point that we need to talk about, and I'd probably lean on Dark to help me explain this. But there was a water budget figure in there that shows that the water budget balances at 30 years. But that doesn't mean that in the modeling that groundwater levels didn't continue to decline. And so from a groundwater level decline standpoint, not all areas achieved stability or no decline at 30 years. Some of those areas, some of the sub areas, and I have to go pull up the exact results again, continue to decline beyond that point. So even though from a water budget
Tim,
standpoint,
can I interject there for a second? So
Yeah.
if I remember correctly, continue to decline in some sub areas of less than 0.1 foot per year. So less than 1.2 inches. Is that what we're discussing?
yeah, some of them were greater than that if I remember correctly. But I'd have to go back and look again.
Yeah, I'd love to have you follow up on that, because I never saw a slide that showed potentially a greater than 1.2 inch decline in some of those sub areas.
Sure. I'd also point out that in all of this, we're talking about the median decline. So that means that half the wells are declining at that rate or worse. So it's possible for wells to be declining much faster than that, but the median was that number we were talking about.
So half the wells would be recovering basically too.
Stable or recovering, yes.
Okay. And did not also in that presentation help me through, Ben or Tim, what it talked about the discharge of surface water and what the alternative be?
Let me pull it in.
So Doug, as they're working through these, so that's also why we increased the voluntary reductions in some of these sub areas, and also why we front-ended some of them more than others, to try to work through that policy consideration of 1.2 inches after 30 years. And if we look at the original model runs that the USGS did, or if you even read the executive, whatever it's called, we also have to understand that the model does have some variance in it compared to the wells that they looked at. Some of the variance compared to what the actual wells were compared to what model results were, 15, 20%, Doug, which we understand that's what's going to occur in a model. But 15 to 20% is probably far greater than 1.2 inches. And that's why we are anticipating and hopeful that the model scenarios that the department will run off the petition we're probably going to take care of that 1.2 inches.
I think I'm just hitting on some of the other highlights. Some of it is just kind of our goal is towards dynamic stability, which we define in the rules, and reasonably stable groundwater levels. We provide a definition there. I am concerned that if I go too deep into all of these, that we will not. I mean, it will take more than an hour. Big picture concept. We also, propose to close the basin. Similar to the department's proposal, we maintain the serious SWAMPA, the serious water management area. Same monitoring, measuring, all of those pieces. Harmony, I think, did I see you? Sorry, just jump in if because I'm looking at two different screens, so feel free to just jump in. Oh, no. Okay.
If I see a hand up, Elizabeth, I'll interrupt you.
Okay, perfect. Maybe one of the distinctions is that we did create reservoirs and then critical groundwater areas for each of those reservoirs. That was important for a couple of reasons. One is to address the issue of transfers between these areas and just kind of the challenges associated with a transfer and how that affects folks who are trying to address drawdown in certain areas. Also, it provides the opportunity to, if you will, unlist an area as a critical groundwater area, again, sort of wanting to account for the fact that each of these areas are different. Not all of them have the same level of declines or instability. And that was something that was important for folks to be able to have a pathway out if they were doing the things that needed to be done to protect the resource. Just kind of skipping over, you'll see that we had, a really high emphasis placed on voluntary cancellation and other voluntary activities. This is something that we thought really needed to get more attention. Again, we want folks to do the right thing, and we want to incentivize them to do that. We talked, again, in each area, we had slightly different approaches. I just would highlight, again, those three areas where we lead with voluntary actions to achieve a percentage that is higher than what was in scenario B. But again, with that regulatory backstop, we also, in each of those areas wanted to have the department ensure that we don't have situations where folks are continuing to develop water in those areas. So you'll see that in each of those areas where we were encouraging voluntary actions, we would still, through the contested case proceeding, have the department step in to ensure we're not continuing to develop these junior water rights, which is sort of counterproductive.
Elizabeth, where are you in the document?
I'm skipping a little bit around, Doug, but I'll give you an example of where that is. If you look in the Silver Creek critical groundwater area, so I'm on page 16. Let me see if I can find that. Yeah, so that would be sub 1, sub A on page 16, and you will see that sort of repeated in some of the other groundwater areas. And then you'll also see in those areas where we really focus.
Can I ask a clarifying question on that specifically, yeah. Elizabeth? So the way I read that, it says the department shall reduce the permissible total withdrawal of groundwater to 0 for any irrigation right or portion thereof where construction of the permitted well was not initiated by December 31, 2024. So if I'm an irrigator in 2035 and I drill a new well and want to transfer over to that because my original well has collapsed, is the department going to regulate me off completely? Because my well was not drilled before December 31, 2024.
That was not the intent, but I can see how why you're raising that question.
Okay.
Tim, our intent there was the same thing. I think that was proposed in the department rules, and that we had conversations in the RAC. And Jason and I had multiple discussions during the RAC. What are we going to do about the permit extensions that have not been developed? So that is specifically on just those permits that had not been developed.
Yeah, because I'm seeing this as causing a problem for basically all transfers
Okay.
going forward.
No, we appreciate that. Yeah, that's not our intent, and we need to work through that. So.
Yeah, if you have some language that would clarify that, please, happy for the help on that. You'll see Silver Creek is a good example of where we had the voluntary focus outright to get to the 10% reductions. Also, just not only focusing on voluntary agreements, but also conservation plans within those areas, so that we're looking just very holistically at how do we, again, incentivize folks to get engaged in voluntary work to achieve and maintain stability. And then if we're not able to, this is a good example on page 16, sub 3, of where if we've hit 25 feet decline, so the voluntary work is not working, then that's where the department would step in and actually go ahead and set PTW and proceed down that line.
Is the intent here to stay within that original 30 years? I see that if you hit the trigger, the department shall set a permissible total withdrawal amount necessary to reach dynamically stable groundwater levels within a reasonable amount of time, not to exceed 30 years. Is that 30 years from the time that we trip, which could be, 15 years down the road from today? Or is it within the original 30 years that we've been operating under all this time? What is the intent?
I mean, the words were intentional there, Doug, because it's sort of hard to know. I think there may be different circumstances in each of these areas. So it says not to exceed 30 years. So there may be a scenario where it makes sense for it to be 30 years. There may be a scenario where it makes sense for it to be shorter, just for the reasons you described.
Okay. C above that, under 2C, the department shall monitor and develop programs to restore and protect spring discharge fed by the Silver Creek Reservoir. I mean, fundamentally, what's going to protect and restore spring discharge is reduced pumping.
Yeah, perhaps. I think this is where we have a bit of a disagreement on the amount of analysis that's needed. And so this maybe reflects that we would like the department to do more work on gathering more data to understand better what the correlation is, if you will, between those two. And also, collecting data while these voluntary agreements are going into place is important. So I think that may just be an area where we would like to see the department invest some more resources to get more information in that area. Mark, please jump in if I got that wrong.
No, I think you're correct. I mean, I would look maybe even to Dark or Jason. I mean, the USGS groundwater study said that was probably the least area that we had the most knowledge on, was the pumpage compared to the springs. And when you talk to a lot of the community, they want to make sure that those springs can continue to run at the current rate. But we're not sure, and we're not sure the science says that lowering, 29% or 24% in Silver Creek will do that. If we fill up Weaver Springs and the water stops flowing into Weaver Springs, will those springs actually run more than what they are now? We don't know yet, Doug. And that was a lot of the conversations we had with the refuge. And that's why the refuge was willing and did sign on as a chief petitioner, is so maybe we could learn more about where the direct impacts for those springs are occurring and go through. And Tracy, I saw your camera come on. Is there something you'd like to say on this one, or no? Okay. So, but maybe Dark could explain more about what the USGS study and the correlation it had there.
Yeah, Mark, the study does comment on the relationship between groundwater flow in the Silver Creek area and the discharge, for example, down at the at the Double O Springs complex. If you'll give me a moment to just pull up that exact paragraph, I can speak more directly to exactly what this study does state. Thanks.
Thank you.
In the meantime, Tim?
Looking at 3A, the department shall set a permissible total withdrawal. My reading of the statute, and I'm not an attorney, but I've spent a lot of time looking at these statutes. The statute says that the commission establishes permissible total withdrawal in rule. So how can we, as I read this, 3A does not allow the department to immediately set a permissible total withdrawal and go to contested case. We would have to go through a rulemaking process like we're doing right now in order to establish a permissible total withdrawal, and then we would be able to go to contested case. So from a process standpoint, that adds an additional level of burden and time to this decline trigger. And so this decline trigger, from my perspective, is not quick or effective in stopping declines that would be ongoing and cause this trigger to occur. It doesn't give us the ability to react quickly in any way, shape, or form to that. And we've already spent a long time just trying to get to this point. I just don't want us to see, I don't want to see us in 10 years hit a decline trigger and then have to go through another 10+ year process.
Yeah, so I think a couple comments on that. One is that this was intended to sort of affirmatively say the department shall set a PTW, right? And that does, as a control measure, ultimately get implemented, can only get implemented after you go through the contested case, right? So what we were trying to do here is take out some of the timing concerns you just expressed there, Tim, where if we are seeing that we're hitting that decline trigger, then we've already put into rule that this is the process you're going to follow, right? Is that you are going to set PTW, you are going to go through the, of course, through the contested case, you are going to implement it. So our goal here was sort of the opposite of what you just articulated, which is to be like everybody's on the same page, that when we get to that point, the voluntary actions haven't worked. And so we all know what's going to happen at that point.
Yeah, but the statute says that the PTW must be in rule, and the commission can't delegate its rulemaking authority, so it has to go through a rulemaking, right?
Yeah, I don't think that's a problem. Like, you guys will adopt a rule that says PTW, and then you'd go through the contested case. We're just saying in this rule that everybody anticipates that that's what's going to happen.
Can I help here, Elizabeth, maybe? So Tim,
Yeah.
Our thought was that through this rule process, you would set the PTW. You wouldn't go through a contested case in Silver Creek unless they hit the trigger. If they hit the trigger, you could go through a contested case and already have the PTW set in rule. And maybe you could even, we're willing to work with the department on this, that if we're projecting that the trigger will be hit in 3 years, that the commission or the department could start contested case then to give them the 3-year period to work through so that PTW could be implemented.
So I guess my question back to you, Mark, is the permissible total withdrawal, any imposition or any reductions in use or any imposition by the commission on someone's groundwater right must be based on substantial evidence in the rulemaking record of the department. How could we have evidence in the current rulemaking record of the department in order to impose reductions on a groundwater user in the future when we don't have that data, that future-looking data today?
No, I think what Mark's saying is that we can build that into the rule. Like, if you guys are, let's say it's year, whatever. Let's say it's year 2035, which you guys are supposed to look at these every 5 years anyhow, right? In 2035, you guys are like, the writing is on the wall. We are going to hit 25 feet decline. start the process then. And we can call, I think that's what we're saying, is that if you wanted to call that out in the rule, Tim, to address that concern, that's certainly something we could talk about.
Okay, but again, we have to go through a rulemaking process. We can't establish a PTW here for Silver Creek that says if the decline trigger is met, the PTW will be 10,000 acre feet, and that's what we'll reduce to. Right?
Okay.
Because I what I heard Mark say is put a PTW number in rule here.
No, I don't think.
And I don't know how we can do that. So
Right, I agree.
Yeah, we can work that, but that's areas that Elizabeth and I articulated at the beginning. I mean, we're hoping that we can pull out these areas that give the department, wait, we can't do that, so we can work through them. And we're not going to get them all worked through here, but we'll flag that one. And if you guys could give it some thought, we can give it some thoughts, and maybe we can buffer in some years here so that we don't have to stall in case they do hit a trigger. But I think if we even look at the scenario that USGS ran, Tim, I mean, with no reductions, I think it's decades out before Silver Creek would ever tripped. I mean, we're talking 30, 50, 60 years. And we are proposing reductions far more than no reductions.
so I guess I would point back to the fact that that portion of the basin is overdrawn by definition, and that's what we're trying to correct. It's not it's not just excessive declines, right? And I guess the other thing I'd do is see if Dark's ready to talk about the spring discharge piece. So,
and Tim, I would also like to get that information from you on that it is overdrawn compared to what recharge is. And then also, if we implement a 54% reduction in Weaver Springs immediately, would that area still be overdrawn? I would say no. So,
Dark,
if we could get follow up on that, that'd be great.
Yep.
Yeah, sure. If there's still interest, I can speak to what the groundwater report says about the relationship between groundwater in Upper Silver Creek and discharge down in the Warm Springs Valley area. And this comes from the Gingrich and others 2022 report on page 75. For simplicity, I'll just go ahead and read it. It's a few sentences. It says, deep groundwater beneath the Upper Silver Creek floodplain flows to the south and east toward a broad trough beginning near western Juniper Ridge and stretching down gradient toward Warm Springs Valley and Harney Lake. There's a sentence in there about the Brothers Fault Zone and enhanced permeability. It goes on to say, continued groundwater withdrawal and development in the Upper Silver Creek floodplain ultimately will reduce groundwater discharge to the lower floodplain, including springs of the Warm Springs Valley. And this statement is based primarily on the head relationships, and so on the groundwater flow directions and those contours that were developed.
So I guess coming back to Doug's point, the conceptual model there and the study shows is that groundwater pumping in Upper Silver Creek conceptually is going to have impacts on that spring discharge.
Yeah, I think it's just, again, maybe just looking for more data around that, Tim, and just, trying to get more certainty around that and the concept, and just kind of bearing out the concept a little bit more over time would be what we were hoping for. So I want to keep moving just because I think there's some other really critical highlights that I want to make sure we get your, I just want to make sure I highlight. So this is back up onto page 12, where we specifically called out the types of water rights that wouldn't be subject to corrective controls. I'm sure you all flagged that, but included in there are the muni and quasi-muni water rights. So that is definitely a difference. That was really important to the cities. Also the recreational groundwater rights, and then the water rights recognized, or excuse me, held by the tribe. Yeah, just wanted to make sure that I flagged that. And really quick, Tim, before you jump in, I wanted to also just highlight what Christopher was referencing earlier, which is this important language at the on page 30 of the rules, draft proposed rules, which do talk about the tribes and the co-stewardship proposal, and just making sure that gets wrapped in to the rules. So I went to flag that. And Tim, I think I saw you raised your hand. Yes.
Yeah,
Okay.
I had a question on the exemptions. We've heard loud and clear, obviously, from the cities that they would prefer an exemption, absolutely, as well as the tribes. And we're considering that. I guess my question is on those geothermal recreation rights. I was looking at the rights just the other day. Currently, from what I've found, there isn't a recreation right in the Harney Basin. So that would affect no rights. What if someone does a transfer from irrigation to recreation? Does that immediately take that pumping, make it authorized, and now free up irrigation, like more PTW for irrigation, because it's now exempted from the rules?
Definitely was not the intent. Our intent there on the
Yeah.
geothermal recreational was Crystal Crane Hot Springs, just to be blunt.
Yeah, so Crystal Crane's a commercial right, and we've spent an awful lot of time talking about it, thinking about it, because it is, from a business perspective, a pretty important driver of tourism. I don't meet many people in Oregon who haven't been to Crystal Crane or who aren't going in the next, year. So,
Yeah. So that's
Yeah.
something we'd like to work with you and get the language right on, because that's who we want to protect, Tim. We don't want people to be able to transfer to recreational and increase more PTW. No.
and then there's only one geothermal right that I've found so far, and that's the Harney Electric, I think. So, yeah.
Yeah, and I think in another place we exempted the non-consumptive uses, right? So sometimes those geothermal uses are non-consumptive, but
Nick Green has his hand up.
Oh, I'm sorry.
Nick?
Yeah, just before you move on, I wanted to reiterate some of the things that the cities have put into both the public comments during the hearings, as well as their written comments in response to the rule. We've not submitted comments yet in response to the alternative rules petition. But some of the things the staff indicated to us during those listening sessions in response to our questions were that they had not considered the voluntary reductions that are already in place on the part of the city of Burns in particular to implement water conservation by improving their water distribution system. So they're in the process of implementing a multi-million-dollar public improvement project to replace aging water lines that they anticipate is going to save about 30 to 40% of their total water consumption. And the concern about that not being considered in the rulemaking as proposed by the department is that that is going to create a new lower baseline for the rolling 5-year average that is even more reduced than the one proposed in rulemaking as soon as it's reevaluated. So it's essentially creating a double whammy effect. The 110% of the new normal is going to be 30 to 40% lower than today's normal. So we don't want to penalize the cities for doing what the commission and the department want the cities to do. The second aspect to that was I don't know that the staff had the opportunity, because the cities were not actively participating as part of the RAC, to consider statutory conflicts that are going to be inadvertently created by this rule that are in conflict with existing state statutes governing urban growth boundaries, economic opportunity analyses, state mandates related to where housing has to occur. The cities do not have the authority to refuse water connections to private property owners who apply. And so if you have existing lots of record, somebody's getting sued. I mean, that's just the reality. If we trigger our cap, they do not have a legal basis to deny a connection. And so what we're concerned about and would like to avoid by requesting the exemption is we do not want to become the Burns decision of the Supreme Court. The cities cannot afford to litigate to that level. The private property owners can and will. The third aspect, and again, these are comments that we made, but we just want to reiterate them here. It was unclear how the 110% was derived as opposed to some other number. It was not clear to us in the model where that 10% increase versus 15 or 20 or 5. We're asking for clarification around how that number was derived. And I guess the last one is just more on the common sense side. We're needling at rounding up what is effectively 1% of the total water budget. So a lot of potentially thorny problems that we're introducing for very little net gain basin-wide. We feel it would be far easier and more effective for everybody involved to exempt the municipalities from the rulemaking, because you're already measuring them at a historic population and economic low over the last 70 years. We're going to have to fight like hell to get back to where we were in the 90s. We're not part of the problem. The cities could become part of the solution. But if this were in effect today, we have one subdivision whose final plat is ready to record next month that the city would have had to deny had that rule been in effect. And then they would have been turning back to the state legislature $8 million in state appropriations to increase 30 acres of industrial lands, 30 acres of business park, and 160 new homes. So mom and dad need to talk. This is not a problem the kids should be resolving. I think the easiest path forward for the cities is just exempt them. You lose almost nothing by exempting them. You buy a whole lot of problems if you keep them in under the proposed rules. So just wanted to kind of make those points again, and also say thank you to the staff. We really appreciate the professionalism, the respect, and the quality of the work that they've put into this. And for us coming late to the game, they haven't been too hard on us. So we appreciate that as well.
Thank you for those comments, Nick. I have a question. Where in the petition are the cities exempted?
Yeah, it's
Page 12.
Yep.
Page 12.
I'm glad Tim knows the answer to that question. That means he's read this a couple times.
Rule 60 sub 11.
Got it. Thank you.
Yep.
Yeah, and just really quick, that whole first section has got sort of overlying principles that apply to each of the critical groundwater areas. Doug, if that helps as you guys are trying to follow the way we put that together. So I feel like I've sort of hit on the highlights, and I don't know if you guys have questions about other specifics in the petition, but I want to make sure, I mean, a big part of this meeting was to talk about what the department's modeling looks like. So I want to make sure, we sort of leave some chunk of time for that. And we've got about half an hour. So, Chris, please jump in, or Christopher, apologies.
Yeah, Elizabeth, thank you. And I appreciate everybody bringing all these different points to the table. And I think that just shows how much more time is really needed in this process to really consider things, because there's still a lot of unanswered questions. But big question for us from the tribal standpoint is that, we're again just being curtailed. I've been asking questions. We're here, we're present, and we're asking questions. But again, we're receiving silence. We're talking about rules and stuff like that, but we're not talking about anything to do with the tribal exemption. We're not talking about anything to do with the co-stewardship. So that just tells me, you're focused on models, you're focused on your next step. You're not focused on anything to do with the tribe. You're not focused on making a partnership. You're not focused on even acknowledging our rights. So, it puts us in a position where our focus should maybe be to adjudicate the entire Harney Basin into the tribes. The unadjudicated water is all in the tribe's Aboriginal territory. And we have all right to just adjudicate the entire basin into the tribe's jurisdiction. So, and that may be a 20-year process. That may be 25 years. That might be 30 years. That might turn into a process where you have every Paiute, Northern Paiute band fighting over who has the water right. But that's going to be just a lot of litigation. And it doesn't sound like a lot of people want to do that, but we're prepared to do it. So I just want to make it really clear where we stand, and we're not going to budge. And I just would appreciate if, we could at least get some feedback. We want to know where you guys stand on this stuff.
Hey, Chris, this is Director Gall. We have 2 meetings set up with you, and I thought that would be a more appropriate time to discuss it instead of taking up the afternoon's meeting today. I'm certainly happy to have a call with you after this meeting, but again, I'd like to get through the petition discussion. That was really the intent of this afternoon's meeting.
Sure.
Yeah, Chris, this is Chandra from the governor's office as well. And, just with all due respect and to be frank, I feel like your aggressive tone is going to make this conversation harder than it needs to be. And I don't believe that the department has come here in bad faith. They're here in good faith. We had a conversation at the beginning of this meeting about how we were going to structure it, which included the petition developers walking through that. And we'd heard very strongly that folks wanted to understand where the department was in terms of its modeling. And as Director Gall said, they set up separate meetings to have conversations with the tribe. And so at this point, I would appreciate all of us taking a constructive tone to the conversation.
Yeah, thank you for that, Shanna. And again, I don't try to come off as an aggressive person or anything like that, or try to offend anybody. I'm speaking totally respectful, but I represent the tribe as a general manager, and I am here to make sure that the tribe's not getting shorthanded and that they're being respected on all levels. So, respectfully, we're just here to be heard. And it's historical that tribes aren't heard unless they speak. So we're just trying to be heard. Thank you.
Definitely appreciate that. And we definitely are not trying to silence the tribes. We would love great conversation, but I do appreciate everyone kind of coming in good faith and recognizing that I do think that globally we're all trying to get to the same place here. And I recognize there's some different approaches, and some folks feel like maybe some things have been missed. And frankly, that's why we're having these conversations. So thank you. And I know that we certainly in the department looks forward to those conversations that are going to occur with the tribe very shortly here. So thank you. Sorry, all.
Thanks, Chandra.
So, Doug, as Elizabeth said, we are hopeful that we were going to see some modeling from you guys. Is that still?
So Mark, I think I can jump in there and answer some of that. One question I want to make sure I get out before I lose it was related to the blitz and voltage critical groundwater area. The petition states that there is substantial evidence of well-to-well interference, as well as well to surface water interference, and that's the statutory criteria that's being met in order to designate the critical groundwater area. It's been the department's stance that we don't have substantial evidence for that, and so we would love to see the data and information that you have that supports that designation. Otherwise, I guess it's a tough sell for me to say we have the ability to designate blitz and voltage as its own critical groundwater area and its own groundwater reservoir, and put it in under this petition.
Which of those were you concerned about, Tim? Not the substantial interference, or the between wells, or between wells and surface water?
Both. So on page 8, it says it's proposed to be designated as a critical groundwater area under the proposed rule amendments on the grounds that there's a pattern of substantial interference between wells within the area in question and between wells and an appropriator of surface water whose water right has an earlier priority date. So,
so you don't think that the department's position has been that none of the criteria for critical groundwater area is met if that was a separate reservoir?
If
for
it's
that
a separate,
area?
if it's a separate groundwater reservoir, we don't believe we don't believe we have substantial evidence to designate under that criteria. Yes.
Or any criteria? Sorry, just trying to be clear. Are any criteria or just that criteria?
I would have to go back and review what we have been leaning on, and what is published in the groundwater report is that we have declined excessively declining, and overdrawn within parts of the groundwater reservoir, and it is one groundwater reservoir.
Okay, that's what I was trying to, sorry, I'm not trying to be difficult. I'm just trying to make sure I understand what you're saying.
Yeah. And our position has been and is published in the groundwater report that it is one groundwater reservoir, not 5, as this posits.
Right.
Yeah.
Yeah, I think we would just, yeah, we have a different perspective on that, but
So I guess what I was hoping is that you all have spring discharge measurements or some sort of hard information that we can point to that says, yes, absolutely, there's interference between wells in this area and the senior surface water right. And we would look to amend our groundwater report, probably, if that's the case. Because we would want to include that if we have it. It didn't come up in the 2.5 years of RAC meetings. And man, I hope it would have. But yeah. Harmony, I see your hands up. I'll pause.
Yeah, I mean, I've just been having pretty substantial conversations with the folks in the Blitz and Voltage area, the refuge. I mean, Sawhouse Springs is dry. It has not been flowing since 2014, and it has a 1923 water right. So and in terms of like why, right, I have heard a lot of different theories as to why. The conversations around the relationship between pumpage and spring discharge in that area is a relatively new conversation amongst users in that area. And I think, you know, as you can imagine, is difficult but important to have. I guess I don't want to offer that I have substantial evidence. I just want to offer that, you know, there's an important conversation happening in that part of the basin about, you know, how various water users affect each other, and a desire for them to work collectively to resolve those issues.
And I
Thanks
think,
for that.
yeah, conceptually, again, what we were trying to do is have each of these areas be designated as a critical groundwater area and focus on the criteria that might satisfy that, and so that we could set up sort of the construct that we have in the proposed alternate rules. So just again, I just want to kind of come back to that, and there are people who don't agree that it does meet any of the criteria, but this was sort of the community compromise, was to have it, you know, folks who have signed on to this, even if they don't necessarily agree that it meets those criteria, for the purpose of creating this construct that allows to achieve the stability, maintain, I think we would say maintain, and then achieve stability in some of those areas. But I appreciate you pointing that out, Tim.
Yeah, I totally understand what you're trying to do. And all I'm calling out is that I don't think the department wants to be in a position where we try to designate a critical groundwater area and a groundwater reservoir where we don't have substantial evidence of the statutory criteria being met. I think that would set a bad precedent and is likely to be litigated, and we would not want to be in that position.
Yeah, so if that's the case, what we may want to do is just in that area not have a critical groundwater area, if we don't have substantial evidence to support it. So we can certainly revisit that question.
So when we talk about modeling, Mark, since I know that's where you wanted to head next, we have been working on implementing what we have read in the petition into a modeled management scenario similar to what we've done in the past for other management scenarios. We're working on getting results similar to what we have presented at past RAC meetings throughout this process, maps, figures, etc. And the goal is going to be to compare our when I say our, the WRD proposed rules results with the petition's proposed rules results, so that we can compare those side by side and see what the differences are, as well as trying to give some historic context around it when it comes to numbers like related to natural discharge, ET, and domestic wells. So very similar to what we've presented in past meetings. The hope is to have a memo ready. It is not there yet. We are double checking all of our numbers. We want to make sure we have got this right before we publish anything, because we do not want, we don't want to put bad information out there. So what we have been doing, I'll talk about how we're implementing the petition, and hopefully you can provide feedback on that. So we have our 5 management parameters that we've talked about over and over again when we talk about implementation. We've got, the first one is spatial extent. So for the purpose of this, we're dividing the basin into 5 individual critical groundwater areas. It's the same as if we did 5 sub areas. They'll be treated exactly the same way in the model. But we are using the 5 sub area, essentially 5 area boundaries that were provided to us by Harney County's GIS person, which I know you were on those emails, Mark. And so we're going to present a map that compares the 2 sets of boundaries so that everybody can see the difference between them. From an evaluation standpoint, in order to evaluate effectively, we're going to evaluate though on the department's 7 sub areas. So when we look at different metrics, etc., we're going to compare on the 7. Otherwise, we would have to rerun the department's management scenario in a 5 sub area context, and that's not feasible in the time frame. Nor did we believe it would be an effective way to look at it. It's simpler to evaluate based on the 7 sub areas. For timeline to success, there are different timelines for implementing reductions. We've got Weaver Springs, which is fully reduced by 2034. We've got Northeast Crane, which is fully reduced by 2058. And then we've got Sylvies, Silver Creek, and Lower Blitz and Voltage, which don't have a time frame by which any sort of regulatory reduction is required, or stability has to be achieved. The stability success metric that
Can I stop you on that really quick? Because I'm not sure that, I think you could look at that a different way. If I can just posit that, you could look at it at 10% by 2040. I think that would be helpful to evaluate because that is wrapped into the proposal. And yeah, I just think that's an important part of what we put in there. Again, it'll be through voluntary actions, but those numbers are still part of the rule.
100%. And I'm going to get there in just a minute, Elizabeth.
Okay.
Thanks. So that's the regulatory piece. For frequency of adaptation, so for implementing the curtailment, there were specific schedules, or there was a specific schedule for Northeast Crane. Every 6 years, curtailment was going to be implemented. 24 years of adjustment. It starts in 2028, and the ratios were 30%, 20%, 20%, 20%, 10% over the checkpoints. And then for the Sylvies, Silver Creek, and Lower Blitz and Voltage, there is a 10% voluntary reduction that's required by 2040. And so from a modeling standpoint, we are implementing a 10% voluntary reduction that's spread equally across all pumping wells to reduce pumpage by 10% in those sub areas starting in 2040. So in Northeast Crane and in Weaver Springs, we will use prior appropriation in which to turn off wells. In Sylvies, Silver Creek, Lower Blitz, and Voltage, we're reducing all wells equally just to spread the impact equally across the area, even though that's likely not how it's going to work. But that seemed like the most effective way to quickly get to it without having to pick winners and losers of wells out in the basin that might skew results. Harmony.
Yeah, thanks for running through that. I just wanted to flag, and I really wish Larissa and or Jacob or others were here, because does feel weird, like kind of sharing with you what they're all discussing. That being said, there just really is an interest amongst these groups of folks to like talk through some different scenarios with you. So in the event that conservation could be achieved sooner than 2040, like I think there's an eagerness. People aren't like, oh, we'll put that off a decade. They do want to do it soon. And so that might be something to just consider for the whole group of, how expeditious they can be in terms of implementing conservation actions and how that might affect results long term.
Absolutely, and we'd be more than happy to talk with them and provide technical assistance, running the model and testing out different potential scenarios. They might have voluntary agreements. We are choosing to implement the 10% voluntary reduction starting in 2040 because that is what the rules in this petition legally hold them to. One other thing I want to note is that the 10% reduction comes from 2017, 2018 average pumping. So you average the 2 years together and reduce. So that's less of a reduction than if we were to reduce 10% from, say, 2018, which is what we had modeled scenario B on. Because 2017's pumpage is, I think, what is it, Ben, 4,000 acre feet more, something like that, than 2018's. So, yeah, roughly. Ivan, I see your hand up.
I am sorry, I forget this, but does the petition contain the across the board reduction in duty from 3 to 2.5 acre feet?
In the two areas in Weaver Springs and Northeast Crane, yes.
And we did not, to be clear, we did not implement that. It's not implemented in our scenario. The reductions occur based on what is estimated to be pumped in each well. So as a well is regulated off, we're regulating that off. We're not also reducing by some proportion all other wells in the area to leave more wells on. We just don't have the time or really frankly the necessary information to be able to do that effectively in the model, Ivan.
Thanks, Tim.
So that's how we're looking at implementing the reductions. City of Burns, City of Hinds, Burns Paiute Tribes, quasi-municipal right, the federally recognized Indian tribe rights. Those are all exempted. The pumping is not reduced in those scenarios, primarily because the priority dates are old enough, senior enough that their pumping doesn't get shut off in the WRD scenario or the petition scenario. Crystal Crane Hot Springs, I don't know if it gets regulated off or not. I believe it probably does at the end because it's a commercial right and it's not a recreational right, so nothing in the petition would exempt it. Yeah, and then we have always been modeling non-exempt pumpage and reducing non-exempt pumpage. So the specific exemption for exempt uses was already implemented in the model, and so that didn't affect how we're modeling this scenario.
And just just at a high level, I think a question or concern I would have is the idea of pitting the two scenarios against each other. I mean, my hope is that the department and I understand the reason for the comparison, but I think like at the end of the day, the question is, does the alternative petition still satisfy the department's statutory requirements, right? And so again, there are lots of places, there's a spectrum there of where we could get to satisfying that. And so to me, the more important question is not how does this compare necessarily to the department's rules, but does the petition that we proposed satisfy the statutory standard? And so I think it's just a little different way to frame the question. I still think I understand there's value in comparing the two, but it's just a little different way, at least that I've been thinking about the question. And part of the reason why we asked at the outset, where are their concerns in the alternative that we proposed? Again, just substantial evidence. We could probably find substantial evidence for a few different options or scenarios. And so I think I just want to kind of reframe maybe the question a little bit, again, with the idea of, we know that the department has to protect the resource. And we know that long term that is important for the community too. I just think the question is, can we get there in maybe just a different way? So I think that's really kind of the spirit behind some of the components of the petition. So it's just a little different way. And you may not have been saying that, or I mean say that, but I just wanted to kind of reiterate that thought.
Absolutely. Thank you for reiterating that.
I just add a little bit here, Tim. And it goes back to Chandra's point, and maybe some of my points, is what happened in the RAC. So we had the discussion groups. We were talking about modeling. The department came out in that last meeting in 24 and did, A, B, C, D, and E. And those that were actively involved in the discussion groups thought we would have that iterative process. And I can remember specifically in my mind thinking, all right, we're close. We're going to be someplace between B and C. We're going to land this plane. And we had no more iterative approach. We had the department saying that they could optimize this. And the next RAC meeting, we came out with an optimized model runs, adding 3 other criteria in. And it's really surprised us. And then we took the other 3 criteria out and were presented the final approach for comment. So my goal here would be, if we're not going to meet some statutory requirements in this modeling, or we think we're too far off, talk to us. If we got to put volunteer agreement by 2036, we will. If we need to increase crane back to 36%, we will. Let's not fall into the same trap that caused us to get to where we are here, because the next step isn't being collaborative. The next step is playing this out in a court of law, and we don't want to do that. We don't. So please work with us on that.
Thanks for that, Mark. And thank you for the feedback on the modeling approach. I appreciate that. One last question I had on the rules is related to new groundwater appropriations. And I've asked this question before, and I've asked it of our staff, and we keep coming around to the same conclusion each time. But if you're allowing a new groundwater appropriation, even if you are canceling a right in order to make water available for that new right, doesn't that new right become the most junior right? And if we're curtailing by prior appropriation in an area, doesn't that right immediately get curtailed off? And so why would you not just transfer that right that you are voluntarily canceling to whatever use you want?
So, Tim, we had this discussion too, Elizabeth and I and a few, and I remember you and I having this discussion in the middle of a RAC meeting. So we got to the point is we included that language in the petition, and Elizabeth, correct me if I'm wrong, was to make sure those that had the option with that language in the 2016 rules, that we weren't going to disrupt if they had to find offset water. So it was basically to cover those that had exercised that option in the current rules that are here. So we want to work with you on that too, because we're confused too on how we get there. So
okay.
Because there was several there's a handful that exercise those rules in that option in the current rules that are here. So
Yeah, I think three important things. One, the kind of limited licenses keeps coming up, and like just how does limited use of water kind of fit within this overall, like the future of the basin. The continued concerns about limitations on season of use and, how to address those. And then, there is a preference for voluntary action in portions of the basin where they're working on voluntary agreements. And so, there is an idea there that, not to get ahead of the conversations that they're having, but like, what is the bucket of water? And, how do you accommodate new uses? And in those parts of the basin, that aren't subject to regulation, there is maybe less pressure with regards to prior appropriation, although that's, probably always going to be an interest and concern for folks bringing new water online. But just wanted to contribute that perspective.
Yeah, so I'll reiterate what we've said in the RAC meetings. Limited licenses by statute have no priority date. They are the most junior right. So limited licenses are not likely to occur in an area with active curtailment because they should be shut off immediately if they're authorized. Season of use, the department has a process by which you can adjust season of use potentially, depending on the hydrogeology and a review and the impacts to surface water. Likely it's possible to, in the Harney Basin, adjust season of use from an irrigation season to year-round. Obviously, your rate gets modified so that your total volume of water would be less. But there are pathways for that, for sure. And then again, that last piece is, I have real concerns about bringing on, like issuing new water rights in an area where we are talking about actively curtailing the most junior users. And I don't think I don't think we want that to be the optic. So and I agree with you, Mark. We'll have to look at that scenario for the people that brought water online after 2016, after new rules. So
I do want to clarify that no one is asking, like from the conversations I've had, it's not about increasing the total amount of water use. It's really about how do we meet new needs while not increasing the total amount used. And a desire for greater clarity, specificity, certainty around that with regards to how do we as a community continue to change and grow and adapt as our circumstances change, and not really that those pathways might exist, but people are really not, they're not currently seeing them. And I think that's a significant concern.
And
we
you'll
have several
see,
several hands up. Yeah. Bob and then
Right.
Doug.
Can I just clarify one thing on that? Sorry, that
Sure.
I think is important, which is that, well, clarify and hopefully I'm remembering this right, that the mitigation for the new use has to be in the same area, sort of getting to Harmony's point. And sometimes, a transfer may not work, whereas and especially if we're in areas where we're not seeing declines, it could just be a pathway to get to a new use where a transfer might not. So
I was just asking for a clarification on Tim's comment regarding limited licenses. And just to point out that an aquifer storage and recovery is a limited license. So I hope we're not talking about regulating those off the table, potential mitigation options for the basin.
Yeah, so ASR is appended to an existing right. So it's a limited license on an existing right. So you'd have to have an existing right that has a priority date that would be valid in order to then use ASR to store the water. For AR, you have to apply for a limited license. And that is one, you have to have a water right, a surface water right, in order to put water on the land, and then you have to have a right to reclaim it. And that's a limited license as well, generally during the testing phase. But
Right.
I don't believe we are regulating off an AR limited license with the proposed rules.
Thanks,
Hey,
just wanted to
everybody.
clarify.
Yeah, thank you, Bob, for that. We are seconds from time. We scheduled this until 4, and I apologize, but several of us have a hard 4 p.m. departure because we've got interviews that we're working on today. So I wanted to let you know that this afternoon we will be getting out an agenda for a commission meeting a week from today. And I think it'll be running from 10 until noon. And it will be on basically a hearing for the commission to receive public comment on the petition for rulemaking. So that is what the agenda will say, and it will further clarify that any comments made on the petition will also be included in the Division 512 rulemaking record. So look for that coming out later today. And with that,
Doug, real
Mark?
quick, will we be given a panel to present for a period of that 2 hours?
Yes, on the petition.
Yeah. Yes.
Yes, we can structure that.
Okay. We can work out the details. Go to your interview. Appreciate your
Next
time.
week. Hey,
Okay.
thank you, everybody.
Thank
Appreciate the
you.
good conversation.
Yeah.
Thank you all.
Thank you
Bye-bye.
all.